I ain't giving in, and I ain't giving up. I know I'm gonna win if I just don't stop. 'Cause I believe in love, love, love. I believe in love, love, love. I believe in love, love, love. And I ain't giving in.
Hi, it's Mark Hughes. This is Justice for All Television. Our mission is to pursue fairness and equity and racial justice in Vermont. This is through relationship building, education, and advocacy. Today, we're going to be talking about the withdrawal of Kiah Morris's candidacy from the 2018 elections and her subsequent resignation from the Bennington, as a Bennington Representative, rather. We're going to look into the events leading up to that, and we're also going to talk about what has transpired since. We are joined today by a guest, Sandy Baird. Sandy, you are not new to 17.
Right.
Thank you so much for joining us today.
Well, thank you for asking.
So today, the conversation about Kiah Morris, it continues. Our program today, an African-American legislator in the wake of 2 solid years of targeted racial attacks. The facts are indisputable, and we're going to look at some of the details. How was the case handled? The Attorney General's investigation and the latest and also startling discovery of withheld evidence. And we'll also just talk about, has justice been actually served? And who's investigating the investigators? So a lot of stuff to cover today. And I warn you, this is a pretty technical, which is why I invited lawyers to the program. We're expecting also, hopefully, if we can get a call in here, it would be James Duff Lyle from the ACLU. He's the executive director of the ACLU. So Sandy, I think the conversation, and I think it's really just that the conversation is kind of how things transpired, and I think some of the research that I was able to come up with is the case is really pretty simple. It seems like what happened is back in 2016. What I mean by the case is like I'm talking about the very core of how this all really started.
Mm-hmm.
It seems like of course we across Vermont we have some folks with differing opinions, folks who have different ideas, folks who see the world differently. And I think this started with at least as it pertains to Kiah. This is in this information, just so you know, I got this from the Attorney General's report, just going back and just kind of parsing that, is apparently there was some racial musing online, happened in, I think, August of 2018. And then I think there was one particular incident where I think it was at a public polling place where it was witnessed where this person had, stared, like intently at Representative Morris on a couple of occasions, and then there was a civil injunction that was placed against this particular individual, and I guess that's under not Title 13, that would be Title 12, right?
No.
Can you just explain the difference between
Well, I
a
think
civil
you have to
injunction?
go back and talk about what are the differences between the criminal law and the civil law.
Yes, that would be a great place to start.
So in the civil law, what happens is that the state is the plaintiff in the case. In other words, it's the state versus a person.
Right, state versus a person.
Before you employ the power of the state, there has to be a crime in the first place.
Mm-hmm.
And crimes are outlined in Title 13.
Okay.
And a crime is when the state law is broken. And
we haven't gotten that far yet, though. What we're talking about now is just before such time as anything was filed in terms of criminal charges. What was going on is that there was a civil.
No, I know, but I'm trying to explain to your audience what the difference is.
Okay.
Okay. So when somebody is accused of a crime, you know it because it says the state versus somebody.
Oh, okay.
The state
The
versus,
state versus,
I don't know this guy's name, but it would be the state versus that. I guess he is the so-called white nationalist, right? Okay, so it would be the state versus him, and he has to be accused of an actual crime,
Okay.
which breaks the law. It used to be called a crime was against the peace and dignity of the people of Vermont.
The
Okay.
peace and dignity. I like that.
Okay, that's criminal law. Okay, when you are charged with a crime, you have to, first of all, there has to be a crime, and then it also, you have certain protections in the criminal law. The defendant does. He has the right to remain silent.
Right.
He has the right to a jury trial.
It's Miranda.
No, that Miranda is something different, but
Okay.
those are the rights that a defendant has.
Okay.
And he has a right to face his accusers. He has a right to a jury trial. He has a right to remain silent.
Okay.
And he has a right to be informed of all the evidence against him.
Okay. So thanks for that. And so where we are right now.
Also, in the civil law, we got to talk about, right?
Okay.
There's the criminal law versus the civil law,
Right.
which apparently there was a restraining order of some
Right.
sort.
That's where we are right
in
now.
the civil law, it's one person against another person.
Got
The
it.
state is not involved.
Got it.
Okay, so in that
It's
case,
preponderance of the evidence.
right,
Okay.
in a criminal law, it's beyond a reasonable doubt.
Reasonable doubt.
In the in civil cases, it has to be proven beyond like 51% of the evidence. But
Right.
it's two people. It's
Right.
Mark Hughes versus, for instance, I don't know any of your friends, or anything, but it would be Mark Hughes versus another person.
Right.
And you don't have any particular rights under that.
Got
In
it.
a criminal case, you have the right to a free attorney too. Not in
Okay,
a
so
civil
thanks for that
case.
clarification. So there is a clear distinction here. So
Big,
what
big
so what
decision,
we
yeah.
know, what we do know is that leading up into this, leading up to the point to where there was any conversation on criminal activity,
Right.
there was some civil activity that occurred.
I don't know that. Is that correct? Was there a
this is yes, there was a restraining order that was
Okay,
put.
and
that was
that's
put
a
in place.
civil
This
case.
This is a protection order that was under Title 12, 5131 is what happened. Okay, so there.
And what
after-
was the allegation? Who brought the case? Kiah Morris
Yes,
herself?
yes,
So she
yeah.
sued, in other words,
She sued Max Mish.
Okay.
Right, so that
in
that
a
was
civil
in a
court,
civil court.
and she proved that she had been, what, harassed?
Apparently, I mean, I would imagine that the judge was convinced by a preponderance of the evidence that
And
somehow or
then-
another she felt harassed. So
And
that,
do you
that's
know
what
the
happened.
nature of that order? What was that? What was the?
I'm not privileged to the nature of the order, but I think that for the court, for the purpose of this conversation in terms of establishing what actually happened, I think it's just good background information to understand that there were a sequence of events that occurred leading up into the alleged criminal offense, and that included.
Okay, was that for the criminal case or the civil case?
Well, what we're talking about is the civil case
Okay.
being one of the things that were, a part of the sequence of events that led up to that. So I think that, again, and this was a one-year order. Those are the details that I do know about it. And by the way, the facts that I'm citing to you were from the Attorney General's investigation report. This is the context that I was able to receive to interpret this through. So and basically that's why I think it makes it. You certainly haven't made it. I mean, when you just broke that down very, insightfully. Now it doesn't seem as simple as I thought it was, but
It's not simple.
Right, but those are the facts in terms of what happened prior to the case, and I think that
Prior to the criminal case.
right,
Okay.
but as the case was being investigated by local law enforcement on the criminal side, the local law enforcement in in Bennington, they didn't feel as though that there was enough evidence that rose to the level of a criminal case. Therefore,
Who are you talking about felt that way?
I'm talking about the chief of police,
Okay.
Paul Doucette.
No, the chief of police.
Oh, by the way, just so I want to say this on publicly is that Paul Doucette, the chief of police, as well as Erica Marthage, the state's attorney, we did invite to the program. Neither of them responded. So we won't. I don't want to get into a lot of detail about them because out of fairness to them, I just want to make sure that that's very clear that they were invited to the program. But you were going to say?
I can't remember now, but the police investigate crimes. That's what they do. They don't make the final decision about whether those crimes should be prosecuted.
Right.
They do not make the final decision.
The state's attorney
The state and the judge
makes the
and the judge,
decision, right?
both.
Okay, interesting. So then, what about when the attorney general investigates something?
Well, I don't know who asked him to. Who asked him?
I guess my question is more of a, we'll get more to that, but my question in general is if the police don't decide prosecution, but the state's attorney does, in a case where the attorney general is the head cop as well as the head quote unquote state attorney, how does that play out?
I'll just say how it usually happens. Because what usually happens is the police make an investigation, and then they decide based on the facts that they have in front of them whether to go further with it or not.
Okay.
And if they decide to go further, they fill out what's called an affidavit, which is a sworn statement under oath that this is true and to the best of their ability. They submit it then to the state's attorney. The state's attorney is a county office. Sarah Judge, for instance, is the state's attorney here. And then the state's attorney looks at that affidavit, and then they make a decision whether to prosecute or not.
Absolutely.
Second step. But the third step is submitting it to the judge to decide if there's probable cause to go forward.
Got it. So in the case of the attorney general, that
somebody
would not
must have asked him to get involved.
Okay.
Because
The nature, I guess the sequence of events leading up into his involvement is really not I want to talk more about that in just about 5 minutes, but I was really just getting ahead of myself and wondering, if that sequence of events and who makes the determination to file charges, I guess if it's consolidated to one individual or something.
No,
like
it is
that,
not. As I just said, it's a three-step process, and
So-
it's necessary.
So no charges were filed. No charges were filed at the police level or at the state's attorney level in the county of Bennington.
So you know that, right?
We know that. And also what happened was that by the way, just so for the audience, just to let you know, we did invite the state's attorney for Chittenden County here for this meeting today, and also the chief of police, Brandon Del Pozo, state's attorney Sarah George, and both of them actually, I think Brandon's in the Adirondacks right now, and Sarah, I think, is waiting tables right now. That's what she told me. So she wasn't able to make it.
Well, it is a holiday today,
right, Exactly. So the allegations, but there were allegations, or at least suggestions, that the investigation was biased, and those came from
Who said that?
Kiah Morris.
Okay. And she said what investigation was biased? The police?
The police investigation. So that's I think that was the time, and I'm just piecing everything back together leading up to where we are right now. And I think what that led to is the attorney general announcing an intention to investigate this particular case.
Could be.
Okay. So, and this kind of leads a little bit to your experience in situations like this, because it sounds as though that there is I'm not going to get into specifics on the hope is that when the director of the ACLU calls in, or if he calls in, we'll get a chance to talk about the allegations or the outstanding lawsuit that they have about racial bias in Bennington, the department. But I did want to note it as a backdrop of the conversation, though. I guess what I'm getting at here is the question is generally speaking, if there's an allegation involving, now we won't talk about the police right now, but I want to talk about attorneys, in this case, the state's attorney, if there is an allegation that there is some type of bias in their processes, what is the professional responsibility board's I guess responsibility in this? And
all lawyers are more or less regulated by the professional responsibility code and the code of ethical conduct. That really has very little to do with what you're talking about. The Professional Conduct Board investigates attorneys who are charged with some sort of misconduct. Many of those cases
were charged or who are accused.
If you make a complaint, that's basically a kind of a charge, and so then the Professional Conduct Committee gets involved.
So if Kiah made a complaint,
to whom?
To If she made a complaint to the
No, it was,
professional,
did it go to the
I
professional?
don't know that she
Okay.
did, but the question is if she would have, what would have been the
If she would have,
Right.
she'd have to prove it.
Okay.
And the professional conduct would consider what to do to that attorney. I don't see what kind of allegation in this case that she would have made. If she's going to
I think her allegation was that there was racial bias.
on whose part? The
on the-
police or
No,
the
on the st-
lawyer?
on- well, we're talking about the professional responsibility board, so it would have to be the lawyer because there is a professional regulation board that handles the police. So what?
Are you certain that she made that complaint to the professional responsibility board?
I am not.
Okay,
But
all right.
but my question is if she would have, because I'm assuming she did, but I'm not going to
I
I'm not
bet-
going to I'm not going to talk to you about. I'm not going to I'm not going to sit here.
I'll just talk to you about what the professional responsibility board does. They investigate
exactly what I want to know.
They investigate attorneys for ethical violations.
Okay.
Many times that has to do with the attorney's handling of a client's money.
Mm-hmm.
Sometimes it investigates whether or not the attorney has a conflict of interest. There's a whole code of professional responsibility.
Okay.
It has very little to do with what you're talking about. It's violations of the ethics that guide the profession of being a lawyer.
So it's violation of ethics that provide that guide
Lawyers.
the profession of lawyering.
Right. It has little.
So if Kiah Morris or anybody for that matter thought in the state that, or if had reason to believe that a lawyer had racial bias in the discretion that bias was actually being applied to the discretion of the decisions that they're making, would that not be an ethical issue?
No, they would. She would then go probably where she did go, and that is to the Attorney General's office.
Okay, all right.
But
So
let me just say something about a prosecutor. A prosecutor has an enormous burden on ethical standards.
you also have an enormous amount of discretion.
Yes, but because of that, and because basically prosecutors use the police so much, and have to, for investigations in particular, they have an enormous responsibility to the community and an ethical responsibility to the whole community. And they have the professional responsibility to uphold the Constitution of the United States.
Absolutely. And for those who are joining, I just wanted to let you know we're talking with Sandy Baird right now. We're talking a little bit about the case in Bennington with Kiah Morris. We're talking about the details leading up to the case that we all know, and we're getting schooled right now in a little bit about this whole idea of the attorney professional responsibility.
Right,
So
but I'm not an expert in the Kiah Morris case.
Of course
I
not. Of course not. Yeah.
I am an attorney, and I'm aware of how the law kind of works.
Appreciate it, and that's why I'm so glad to have you here. I wanted to just pivot a little bit away from what it is that you offer in terms of the discussion surrounding the attorney professional responsibility and tell you what I know about the law enforcement professional regulation piece, mostly because the law enforcement professional regulation piece is something that I'm really versed in because I sat on the summer study and also walked through and lobbied, and with this Title 20 work. So Title 20, 2404, notwithstanding the provisional subdivision A, basically law enforcement agencies, they refer to the consul any unprofessional conduct complaints.
Which counsel are you talking about?
The Vermont Criminal Justice Training Council.
Okay, I'm not familiar with that.
Oh, well, that's the reason why I'm kind of bringing it up, because I just kind of want to bring it. And again, like you just said earlier, this is really more for the audience.
Right.
This is the conversation is what happened. This is the whole point. Is what happened. At the time that the initial investigation of this was closed, because I think a lot of us, what we're doing is we're taking a look at this case and we're saying, let's just go straight to the conversation about the First Amendment versus the 14th Amendment and whether or not the Attorney General did his job surrounding the First Amendment. That may or may not be true, but there are other factors that to discuss.
Say what you mean.
I guess what we're talking about here is the fact that there are that what happened is that there was a decision that needed to be made in terms of what to do about allegations of misconduct that nobody is talking about.
Misconduct against whom?
Misconduct against the allegations of misconduct would be allegations against the police department as well as the attorney. Okay, so we talked about the attorney. Now what we're talking about is the police department. So who handles the allegations of misconduct of police department? What I was trying to just update the audience on is it is the Vermont Criminal Justice Training Council. So ominously, what I'm trying to get figured out is where is the Vermont Criminal Justice Training Council in this process? I know you didn't come prepared to have that conversation, but this is part of the conversation. Is that's one of the things.
I don't know what are they being accused of? Are they being accused of something?
Well, here's what the statute says is that if there's a what we're talking about is biased enforcement. Okay,
Right.
this is Title
Right.
Title 20-2401, Section D, biased enforcement. So in the case of any allegations against an executive
Police officer or
no,
police?
an executive officer, that is the chief of police, okay, then that automatically goes, that investigation by statute automatically goes over to the Vermont Criminal Justice Training Council. So that means the council has the responsibility to investigate not the initial case itself, but the allegation of the biased enforcement.
Right.
Okay, so
I don't know. I mean, you're telling me something.
yeah, exactly.
Okay.
So the point here is my curiosity, and part of this program for those who are just joining, we're talking about the Kiah Morris case, is why is it that we're not hearing? Why is it that we're not hearing this whole other dimension, which is this biased enforcement allegation in the Vermont Criminal Justice Training Council's response, or what should have been a response from the council? Has there been a professional conduct complaint, first of all, referred to the Criminal Justice Training Council by the Bennington Police Department? And then the next question is did the Bennington Police Department, I beg your pardon, did the Bennington Internal Affairs folks conduct this is quote out of the statute, a valid investigation in response to the allegations of the biased enforcement?
We need to know if there was a complaint made. Do you know if there was?
Well, no, I don't. But by statute, the complaint can come from anyone. So the complaint is a public complaint.
Yeah, but is there one? Did somebody make a complaint to them?
So let me get this right. So what you're asking is did somebody make a complaint to the Vermont Criminal Justice Training Council?
Yeah. Right. Do you know?
I don't know if there was that was the question that I just asked. Has there been an unprofessional complaint referred to the criminal justice?
Yeah.
You're asking the same question that I'm asking.
Yeah, but I think who would have had to do that would have been Miss Morris, I think.
No. The statute says is the police department, because
Okay.
first of all, what we're talking about is we're talking about an allegation of a biased enforcement.
Right.
That is where Miss Morris would need to make the complaint. But after that allegation was made, and we know that was made, okay, the police department, based upon Title 2401, the statute says that should have automatically invoked their internal affairs process.
Does
okay?
it say automatically?
Yes, it does say automatically, and so that's what the statute says. So, and the statute says is that as a result of that internal affairs process, if the chief was implicated, the statute says that the Vermont Criminal Justice Training Council must automatically take up that investigation.
Well, we don't know if it happened or not.
We don't know
right?
if it happened or
Right.
not. So these are just the questions that I'm asking.
Yeah.
Certainly not asking you. It's not. I mean, this one's not yours, right? But these are, I think, the other questions that I don't know that folks are asking, because everybody's just making a rush to make a public judgment on what the Attorney General did or didn't do, as opposed to asking these other types of questions. So what about that? The third question is to what extent is the Vermont Criminal Justice Training Council investigating allegations that the Bennington Police Department did not conduct a valid investigation. Okay, so these are things that are all outlined in Title 20, 2401, and 2404. Okay, for those who are just joining us, this is again about the Kiah Morris. I'm going to call it the affair, but I hate to say affair because then I start thinking about Irisburg and all that other stuff, But the Kiah Morris incident that happened down there, I've got, probably one of the smartest attorneys in Chittenden County with me.
Hey. No, and I'm certainly there are people that are a million times more expert about this than I am. I am just attempting to shed a little light about the usual process that goes on in these kinds of decisions.
I really appreciate you joining me. Yeah. Appreciate it. I'll talk a little bit about the AG's investigation. We'll just change the page and we'll get more to that because I think that's really more what you're going to be more helpful and more comfortable. But before we do that, I want to just take a quick break and tell you about what's coming up next month. What's coming up next month? Well, we've got Who's Watching VTPD. That's a police oversight. Want to have a conversation, just a little conversation about oversight across the state. Why is that? Why is that such a bad word? Why is there so much silence in our so-called progressive liberal communities about police oversight? Could it be that people are content with the status quo, apprehensive about making waves? Constitutionally, statutorily, is there anyone really overseeing the police? You'll be surprised what we find. That's Who's Watching VTPD. That's going to be next month on our program. Please join us. That's going to be March 14th. Again, Who's Watching VTPD. So back to the discussion here. We're joined by Sandy Baird here in the studio, 17 Studios. We're talking about the Kiah Morris incident, the investigation that the Attorney General had taken up. We know the events. We've talked about the events leading up to it. Rather, we've talked a little bit about the thing that most people are not talking about is if there was an allegation of misconduct, and in this particular case, racial bias in the investigation by the law enforcement or even by the state's attorney. If that were the case, then what role, if any, does the law enforcement professional regulation process play? What role, if any, does the attorney's professional responsibility board play? And then more specifically, with law enforcement, we talked a little bit about the statutory responsibility of the Vermont Criminal Justice Training Council. And in all fairness, I invited Rick Gauthier, the Vermont Criminal Justice Training Council's executive director, to this program. He was unable to be here. I did send him, as I also sent the Attorney General, some questions to answer on this program. I didn't receive a response from either of them. In all fairness to TJ left me a voicemail last night. He said, "Hey, Mark, I'm glad to talk to you about it." So although he wasn't able to respond, he did, make the effort to reach out to me and close the loop. So all of that stuff, we want to be fair to everybody involved in this process. Now, regarding the investigation itself, the outcome of the investigation, Sandy, what I'm looking at here is I just want to read it to you and just see if I can get a response. Not really a question, but just, but this is the AG investigation. It says, I'm going to quote it. It says, regarding the online communications directed against Ms. Morris by Max Mish and others, there are 3 potential charges that could be filed under Vermont law. These are disturbing the peace by use of the telephone or other. This is other electronic communications in violation of Title 13, 1027. Criminal threatening in violation of Title 13, 1702. And also stalking in violation of Title 13, 1062. It goes on to say that each of these statutes can potentially be violated based on communication of threats. However, in order to establish that a person violated any of these statutes by conveying threatening communication, the state would have to demonstrate that these communications were not protected by the First Amendment to the United States Constitution in Article 13 of the Vermont Constitution collectively. So your thoughts on that?
You have to understand that a crime is a very serious matter, and people don't. The state does not investigate you in the first place unless there is some kind of a crime, and a crime would be if Kiah Morris was threatened by those communications directly.
Okay.
I think what that the Attorney General decided in the long range was that there was not a crime. There was miserable, wretched, condemning speech, but that there was not a crime because there weren't direct threats at Kiah Morris. That's what I think he decided. And that, I think, is in accordance with his responsibilities to meet the Constitution. If there is no threat, there is no crime.
Yeah, let's talk about that. Let's talk about his responsibilities, because we were talking about it off air a little bit, and I just wanted to make sure, because you were saying some really good stuff. I wanted to hear more about that. The Attorney General's constitutional responsibilities, and how do those weigh out in his process in charging crimes?
Everybody, but prosecutors in particular, because they have such enormous power, have to meet the requirements of the United States and Vermont constitutions. Police don't get to really investigate you unless you've been accused of a crime. The other ethical, and so in this case...
For a minute, can I just ask you, can you just make that, draw a little bit of that distinction between what law enforcement is doing in terms of enforcing law?
If I called up the cops and said, I want you investigated because you said nasty things to me, cops would say, there's no crime. I'm not going to butt into his life. If, however, I had proof that I was threatened by you, then the police might look into it. And I think in the Attorney General's case, he did look into it and decided whether you agree with him or not is a different question, but he decided that there wasn't really a crime. And so therefore, he didn't really have the power to go further in that case and charge anybody with a crime. He also decided that what was done to Miss Morris, which was horrible, met the protection of the First Amendment, which is free speech.
Let's talk a little bit about that. So what we have here is we've got, again, this is all quoted from the report that the Attorney General filed, and this is all consistent with some of the things that you were saying, but I just wanted to let you say it first. Here's some of the justification. Because the free speech protections afforded under the First Amendment, quote, content-based restrictions on speech. This is the U.S. versus Alvarez. And then there's a discussion on true threat. This is Watts versus the United States, U.S. Supreme Court, rather. This was about the whole idea of the Vietnam veteran that was allegedly threatened to kill the LBJ. And then there's Virginia versus Black, which is the cross-burning incident. The State versus Tracy, which is right here. This was whether speech constitutes a true threat. So just a lot. There's a lot of case law that the Attorney General presented. Yeah. So he presented a lot of case law, which kind of, I don't know. In my mind, I was thinking to myself, well, wait a minute. The Attorney General. Now, for the Attorney General, I thought was coming in to investigate Max Mish to determine whether he committed a crime. But it seems like what the Attorney General did was built a defense for him. So that's what I'm kind of a little bit...
The Attorney General defends the Constitution of the United States and the Constitution of the state of Vermont.
With discretionary authority.
You have to remember that.
So at any given time, and I understand, we all should remember that.
Yes,
to include
please.
the Attorney General.
And to include special prosecutors when they're investigating President Trump.
Exactly. So at the end of the day, because of the Attorney General's dual role, at any given time...
Doesn't have a dual role.
The attorney...
Does not.
Well, for the purpose of this discussion, what I will say is that the Attorney General defends the civil liberties of folks in this state, and he also prosecutes the law. Those are
That's
two
not a-
separate rules, okay?
No,
Roles,
they're-
rather. So what I'm getting at, if you'd allow me to say it, is that there is a responsibility that the attorney has to protect the state, to defend the state, right? And then he also has a responsibility to also defend people, right?
He
To
has,
protect
as I
people,
said
rather.
before, as I said, he has an ethical responsibility to protect all the people of the state of Vermont, including the defendant, and he has a responsibility to uphold the Constitution of the United States.
Good. So here's what we'll say on that is that what he decided to do here is to refer to case law, okay, and to support the fact that the allegations
Right.
of crime did not rise to a level
Of a crime.
of a crime because of the fact that there's case law that he wanted to provide that indicated that freedom of speech took precedence.
Yeah,
over
but
this,
he
okay?
knows, he also is a man who's familiar with the First Amendment.
As am I.
Right.
Okay, so here's the rest of what he quoted is in this case the online communications that were sent to Ms. Morris by Max Mish, the others were quote clearly racist and extremely offensive. Okay, then I'll just move through this and I won't go through the whole thing. But he also noted that the question here is whether the messages in context were communicating a serious expression of an intent to harm Ms.
Right.
Morris or family.
Right,
Okay.
Right.
And then the last part is his conclusion is he said, therefore, it appears to be insufficient evidence to pursue criminal charges in the state of Vermont.
Right.
Okay. So the Attorney General's conclusion then is consistent with exactly what it is that you just said, and that is he made the decision that it was important to focus on the First Amendment and the constitutional law that upholds the First Amendment. Let's look at the law, okay? So you can't see it on your screens at home right now, but I guess you will because we're going to record this. Here's what the law says. Title 13, it says that this is 1455. This is one of the laws that was not stated in what I just read about what I quoted the Attorney General saying that there were 3 laws that applied. This was not one that was stated in his report. It says a person who commits, causes to be committed, or attempts to commit any crime whose conduct is maliciously motivated by the victim's actual or perceived race, color, religion, national origin, sex, ancestry, age, and so forth, okay? So again, it says a person who commits, causes to be committed, or attempts to commit any crime whose conduct is maliciously motivated.
What's the crime?
So it says any crime. This is the statute. This is the statute. It says any crime, okay? So, and it doesn't say commit. It doesn't say causes to commit. It says commits, causes to commit, and also attempts to commit. So that's the first one.
Crime.
A crime.
Okay.
It says any crime.
Right.
Any crime.
Right.
And it says, and now the circumstances under which it says whose conduct. So now we're talking about what is this person, how's this person conducting themselves? Is maliciously motivated by the victim's actual or perceived, so on and so forth. So that's hate crime. So that would be Title 13, 1455. Now we'll move on. I'm going to just lay out about 4 crimes, 2 of them which the Attorney General cited. But just keep that one in mind because that one right there, that's the first one and that's the kicker, okay? Because all these other ones, these are the, like you said, what's the crime? These are the other crimes. But keep in mind that this first one says even attempts to commit, okay? So this says that this is simple assault. This is also another one.
Simple assault.
This is Crimes and Procedures, Title 13, 1023, the statute. Simple assault. This is a definition of simple assault. Simple assault is, we can talk about, causes. Number 1, attempts to cause purposely, knowingly, or recklessly causes bodily injury to another, or negligently causes bodily injury to another with deadly weapon, or, here's the third one, it says attempts to physically menace, to put another or in fear of imminent, serious, or bodily injury. So that would be the crime of simple assault. So we see there that there is a criteria whereby just the simple fear of imminent, serious bodily harm is a condition whereby which this crime can be charged, okay? And now here's the third one, and this is Title 13, 1027, and this was cited by the Attorney General in all fairness. This says a person with intent to terrify, intimidate, threaten, harass, or annoy makes contact by means of telephonic or other electronic communications with another, okay? And then it goes on and says disrupts, attempts to disturb by repeated telephone calls or other electronic communication. The peace, quiet, right of privacy of any person at the place where the communications are received. So that is Title 13, 1027, and it continues, and it says, an intent to terrify, threaten, harass, or annoy may be inferred by the trier of fact. And then it also goes on to talk about repeated telephone calls or other electronic communication. Then there's also stalking, okay, which is Title 13, 1061, which is course of conduct. This means 2 or more acts over a period of time, however short, in which a person follows, monitors, surveys, threatens, or makes threats about another person or interferes with another person's property. It goes on to say stalk means to engage purposely in a course of conduct directed at a specific person.
Okay, I think we only have a couple minutes left, so.
I think we're going to go a little bit further.
Well, I don't know about that.
So here's
because I have something else to do, but I'll tell you something.
Well, before you go on, let me just finish this last thing. It says the person engaging in conduct knows, should know, cause reasonable person to fear, cause a reasonable person to fear. This is very important. This is the reason why I interrupted you. This last part, for his safety or the safety of another, would be cause a reasonable person substantial emotional distress. So, you were saying?
You said you basically have already decided what you think.
Mm-hmm.
I'm just going to tell you what I think.
I don't have an opinion yet.
Well, it seemed to me that you do.
I was just reading the law.
But you have an opinion about that law.
I don't.
My opinion about the law and about the Attorney General's decision, as I understand it, is that he concluded that whatever the communications were, while offensive and probably racist, were not a threat of physical harm. He therefore decided, I believe, that there was not a crime, even as you defined it by reading those laws. I believe that was what his decision was. And remember that these communications, in his opinion, meet the requirements of the First Amendment. And so maybe, and you
I get what you're saying.
obviously disagree with that. I'm just saying what.
I don't know that I disagree with it or not. I think I'm on the fence right now. What I'm trying to do is put all of the facts out. Let everybody else decide what it is that I think that what we've just done is we've just covered the communication that came from the Attorney General. The Attorney General, obviously, I've made every effort to make sure that the Attorney General was aware of what we were talking about, and in all fairness, provided him full opportunity, and will be going back and having additional conversation with him in other settings. There is a conclusion that he came to. He made certain decisions, and there are laws. Now, those were not opinions that I was reading; those were statutes. Okay, so at the end of the day, here's the questions. Here's the questions for the Attorney General. And as we close, is that, and I sent these questions to the Attorney General already. He has these questions. I sent them to him. So, what specifically precluded the Attorney General from filing under Title 30, 1023, 1027, and 1061? So. That question.
I have to interrupt you because what I already said is what I believe the basis of his opinion is. He was of the opinion that there were no threats of physical harm.
Well, let's be clear. These are not your questions. This is not for you to answer. This is the Attorney General's question.
I know.
Okay? I didn't really invite you to defend the Attorney General.
No, but
I just wanted your legal opinion.
That's my legal opinion.
Thank you.
Okay.
But what I'll do again is give these questions to the Attorney General. They are his to answer, not yours. Okay. So here's the second question for him.
Mark, you asked me to be on this show, and
I know, but what I'm saying, I wanted your legal opinion.
That's my opinion.
I thank you for your legal opinion, and I'd love a legal opinion on the next one.
Yeah.
Here's the next question.
Okay.
The Title 13, 1455, which is hate crimes, states that a person can be charged who commits, causes to be committed, or attempts to commit any crime whose conduct is maliciously motivated by a victim's act or perceived race, actual or perceived race. So, is there any? This is to you, TJ. Is there any consideration being given to rethinking this decision to not use this charge? And then the third question is why did you suggest an independent contractor to investigate the Bennington Police Department when Title 20, 2401 calls for the Vermont Criminal Justice Training Council to do so, as per their professional regulation requirements? Why even get into it, I guess is what I'm wondering, because there's a statute that addresses that. And I guess, did you supplant that process in doing so? So those are the questions for the Attorney General. Again, I want to make it very clear, this is all these are the conversations that we need to have. And as you can see, these conversations are not easy conversations, but they're still conversations that we need to have. It's good to have professional advice and opinions on it, but also those people that we elected to be our public officials, those folks who have those responsibilities that we charge on a daily basis. It's not just our right, but it's our responsibility to call them into accountability on questions like these, because we are the citizens that put them in place, and we want to make sure that they're doing the right thing. So I think that for those who are joining us, again, thanks for coming out. This is Justice for All Television. I've had the distinct pleasure of having Sandy Baird with me today on this program. What we're trying to do is we're just trying to get to the bottom, if you will, ask all of the questions, ask all of the right questions on this program. I think we've done a pretty good job at unpacking most of this conversation. I think that, what I'll do is I'll commit to you to coming back with, the things that I get from the Attorney General, as well as the Vermont Criminal Justice Training Council Executive Director, their comments, even have them on the program to be able to come and provide their own responses to these answers and so forth. Bring this conversation down to a local discussion by bringing our own Chief of Police on the program, Brandon Del Pozo, who's a great friend of mine. I really love and respect. Sarah George, having these conversations. This is Justice for All Television, where our vision is it's a nation where restorative dialogue enables us to become empowered and moves us beyond a legacy of racism and oppression, and it causes a change in the hearts and the minds of our current as well as our future generations, and a nation where our judicial system and our peace officers are accountable to our citizenry, I can never say that right, committed to protecting all of us and providing justice for all. Sandy, thank you so much for joining today, and thank you for joining us.
Across the ocean, fleeing inhumanity, landed here